Security deposit procedures. Security deposits are a frequent source of conflict and an area of strict regulation. A security deposit is money given by the tenant to secure performance of lease obligations, such as paying rent and repairing damage beyond normal wear and tear. Most states require that security deposits be held in a special trust account separate from the manager's or owner's operating funds. The funds may or may not be allowed to earn interest. If interest is allowed, the law usually specifies whether it belongs to the owner, the tenant, or perhaps to a state program. The funds cannot be used for any purpose other than those allowed by law and the lease. The law also sets deadlines for returning security deposits and for providing an itemized list if any part is withheld. For example, the owner or manager may have a fixed number of days after the tenant vacates to inspect the property, determine whether there is unpaid rent or damage beyond normal wear and tear, and send either a refund or an itemized statement with any remaining funds. The lease should explain these rules in plain language. It should state what can be charged against the deposit and what cannot, and it should describe what happens to the deposit at the end of the lease, when it will be returned, whether it can be applied to last month's rent, and how disputes will be resolved. For managers, careful move-in and move-out inspections with photos and written condition reports are essential to defending decisions about deposits. Uniform Residential Landlord and Tenant Act. The Uniform Residential Landlord and Tenant Act was drafted to make residential leasing fairer and clearer. Many states have adopted versions of this act. Arizona, for example, has separate acts for standard rental housing and for mobile home parks. The act is designed to clarify lease language and set out fair remedies when either party breaches. It addresses issues such as lease terms, rent, security deposits, landlord access, default procedures, and the general obligations of both landlord and tenant. Its goal is to reduce confusion and prevent exploitation by spelling out rights and responsibilities that may have been vague in older leases. For exam purposes, remember that uniform acts like this create a common framework. For practice purposes, you should always know which version applies in your state and never assume that the lease alone controls. The law will override lease language that attempts to remove basic tenant protections or landlord rights. Property management accounts and trust funds. Trust accounts are a critical part of property management. They are where managers hold client money, such as rents collected on behalf of owners and security deposits held for tenants. To protect the public, the law requires that these accounts be clearly identified and carefully handled. All property management accounts must be designated as trust or fiduciary accounts in the account title. Examples of acceptable designations include trust account, fiduciary account, or in trust for followed by the individual or entity name. This makes it clear to the bank and regulators that the funds belong to clients, not to the brokerage. Generally, all owner monies must go into a broker's trust account unless the owner directs that funds be deposited directly into the owner's own account. If funds are deposited into the owner's account, the broker usually should not have access to that account. Trust accounts may be interest-bearing if permitted by law, but the management agreement and law must specify who receives any interest. The designated broker may authorize certain people to transfer money or sign on the property management trust account. These individuals may be licensed or unlicensed, but if unlicensed, they must be true officers, members, principals, or employees of the firm, not outside contractors. Even when others are authorized to sign, the designated broker remains fully responsible and liable for all money handled. Funds must be deposited promptly. Many rules require that, within a certain number of banking days, often 3, all monies not subject to dispute or contingency must be deposited into either the owner's direct account or the firm's trust account for that owner's benefit. Rent collected in cash, for example, should not sit in a desk drawer for a week. Each rental agreement should clearly state how tenant deposits will be held and what will happen to them at the end of the lease. Accurate records must be kept for every trust account. including deposits, disbursements, reconciliations, and owner statements. Misuse of trust funds, commingling client money with company funds, or failing to account is one of the fastest ways to lose a real estate license. Criminal history and fair housing screening. Screening tenants is one of the most important leasing tasks. It is also an area of growing fair housing risk, especially when criminal history is considered. Many owners and managers want to avoid renting to people with serious criminal records for safety reasons. However, federal fair housing law prohibits discrimination based on race, color, religion, sex, disability, familial status, or national origin. Criminal history itself is not a protected class, but policies that use criminal records in a broad or automatic way can have a discriminatory effect on protected groups. Across the country, certain racial and ethnic groups are arrested and convicted at higher rates than their share of the general population. If a landlord or manager adopts a blanket rule that anyone with any criminal record is automatically rejected, that policy may have a disproportionate impact on those groups, even if the landlord did not intend to discriminate. This is called disparate impact or unintentional discrimination. Current federal guidance says housing providers must be more careful. They should not treat mere arrests the same as convictions. They should avoid automatic lifetime bans for any conviction. Instead, they should consider the nature and severity of the crime and how much time has passed. For example, a recent conviction for a violent offense might be treated differently than an old conviction for a minor, nonviolent offense. The policy should be related to a legitimate, non-discriminatory interest, such as protecting resident safety and property, and it should be applied consistently to all applicants. For property managers, this means reviewing and updating screening policies, training staff, and being prepared to explain how a criminal history policy is necessary and reasonably tailored. It does not mean that criminal history can never be considered, but it does mean that automatic, overly broad rules can create fair housing liability. Good documentation of criteria and decisions is essential. Review summary. In this section, you tied together general leasing principles with the practical realities of property management. You reviewed the main leasehold estates and saw how estates for years, periodic tenancies, tenancies at will, and tenancies at sufferance affect when and how leases begin and end. You learned how different rent structures, including gross, net, percentage, and graduated leases, shape cash flow and risk. You examined how inclusions and exclusions in leases, from appliances in a small apartment to build-outs in a shopping center, affect maintenance obligations and insurance coverage. You saw that owners retain reversionary rights and that property managers must remember they are safeguarding the long-term value of the asset, not just the current tenant relationship. You explored landlord rights to enter, collect rent, and retake possession, as well as their duties to provide a habitable property. You also explored tenant rights to quiet enjoyment and habitability, and their duties to pay rent, follow rules, and care for the property. You compared actual eviction, which follows a court process, with constructive eviction, where a tenant leaves because the landlord has failed seriously in their duties. You looked at tenant improvements and how leases allocate costs and ownership. You covered the many ways leases can terminate, including expiration, agreement, abandonment, default, notice, destruction, condemnation, foreclosure, and death. You learned how security deposits must be handled in trust, with clear timelines and explanations. You reviewed the purpose of the Uniform Residential Landlord and Tenant Act and saw how it provides a framework for fair, clear leasing. You emphasized the importance of trust accounts in property management and the broker's continuing responsibility for all client funds. Finally, you learned that screening based on criminal history must be handled carefully to avoid illegal discrimination, with policies tailored to legitimate safety concerns and applied consistently. Together, These leasing considerations form a critical part of the national knowledge base for any real estate salesperson involved in property management or advising landlord clients. Discussion Prompt 1. An owner wants a simple lease that says, "No criminal records allowed," and nothing more. As a property manager, how would you respond based on what you have learned about fair housing and screening policies? Suggested answer. You should explain that while the owner may legitimately want to protect residents and property, a blanket ban on anyone with any criminal record can create fair housing risk because it may have a disproportionate impact on certain protected groups. Instead of a simple no criminal records rule, you should propose a written screening policy that looks at the nature and severity of offenses and how much time has passed, and that is applied consistently to all applicants. You might recommend that the owner consult legal counsel to review the policy. This approach balances safety with compliance and reduces the risk of a discrimination claim. Discussion Prompt 2. A tenant moves out at the end of a 1-year lease, leaving unpaid rent for the last month and several broken interior doors. The security deposit is equal to 1 month's rent. What steps should the property manager take regarding the deposit and documentation? Suggested answer. The manager should promptly inspect the unit and document its condition with photos and written notes. They should calculate the unpaid rent and the reasonable cost to repair the broken doors. Then compare that total to the amount of the security deposit. Within the time required by law, they should send the former tenant an itemized statement showing how the deposit was applied to unpaid rent and repair costs, and either refund any remaining balance or explain that the deposit does not cover all amounts owed. The manager should keep copies of inspection reports, invoices, and correspondence in case of a dispute. Discussion Prompt 3. A commercial tenant has installed several interior walls and custom lighting under a 5-year lease. The lease is silent about what happens to improvements at the end of the term. The landlord wants the walls to remain. The tenant wants to remove everything. How could this conflict have been reduced or avoided? And what should a property manager do in similar future leases? Suggested answer. This conflict arises because the lease did not clearly address ownership and removal of improvements. To reduce future conflicts, the management and leasing team should work with legal counsel to include clear clauses about tenant improvements, including who owns them, whether the tenant may or must remove them, and what condition the space should be in at lease end. In the current situation, the parties may need to negotiate a solution, perhaps allowing some items to remain with compensation or sharing removal costs. For future leases, the manager should insist on detailed language about improvements and restoration so expectations are clear from the beginning. Closing remarks. Leasing is where the law, the business plan, and people's daily lives or businesses all meet. A lease is more than a piece of paper that says how much rent is due on the first of the month. It defines who may enter and when, who fixes what happens to deposits, how long rights last, and how they end. For a property manager or salesperson, understanding leasing considerations is essential to protecting clients, staying within the law, and avoiding costly disputes. As you move deeper into property management topics, keep coming back to the lease. If you can read it, explain it, and enforce it fairly, you will be far ahead in both exam readiness and real-world practice.